Estate planning. We're all told to do it, but so many of us continually put it off. What is it, and why is it so important? I'm joined tonight by attorney Richard Shaffer to discuss those questions and more. All of that is coming up right here, right now. I'm Chen, and this is Face the Issues. Good evening and welcome to Face the Issues. I'm your host, Chen. Estate planning. We're all told that we should do it, but so many of us continually put it off. Some of us don't find it necessary. So what is estate planning? What does it entail, and why is it so important? Joining me tonight is attorney Richard Shaffer of counsel at Swartz & Associates to discuss those questions and more. Richard, thank you so much for taking the time to be here.
Thank you very much.
Absolutely. Let's start with the basics. Estate planning, everyone has heard of it for the most part. We are constantly being told that we should do it. There are ads on TV about it. But what is estate planning?
So estate planning basically is like insurance. Everyone should have it. It's basically, it's three main documents: a power of attorney, an advanced healthcare directive, and then a will that can or cannot have a trust associated with it. Now, in more intricate estates, there may be more trusts that are required, but in a basic estate, for most people, it's those three documents.
And you, right off the bat, you said everyone should have it, that this is something that you recommend for every individual. Why is that? What's the importance behind it?
Well, the importance is it's planning for an event where someone would either be incapacitated or unconscious. And in those situations, the power of attorney or the advanced healthcare directive, they would kick in, and then an agent who is named would be able to make decisions for the individual until they gain capacity again.
Okay. Is there a normal, I think for a lot of people, especially young people that I talk with, they kind of have this mentality that, well, I don't really want to, I'm young, I'm healthy, I'm never going to be in a place, at least not now, where I'll be incapacitated. What's your recommendation for, is there age at which we should be looking at it, or do we do it as early as possible?
No, it's something that you should do as early as possible, and it shouldn't be that expensive, particularly if you were young, then you don't have a very intricate estate, and so it's just three basic documents. The reason why even young people should do it, for instance, and to get into what the documents are, like a power of attorney, what it does is it names an agent to make financial decisions for you. So, for instance, if I got in a car accident and I named you my agent, you would be able to pay my bills for me and make sure my finances were taken care of until I gained capacity and could do it for myself.
So this is not necessarily even someone is preparing to pass, that they're getting their estate in order. This could be something as simple as somebody is unconscious in the moment and they're going to recover, but in that intervening time, there needs to be someone who can make decisions for them.
Absolutely. In fact, even when you include the will, we always tell clients all we're planning for is the next 5 years.
Okay.
And then they should review their documents in 5 years and then really look at them closely in 10 years and make sure they meet their needs or what the goals they're trying to achieve.
So this can all be amended as well then? This is not something that's written in stone and final?
Absolutely. In fact, we tell our clients one of the things is it's not Moses on the mountain where it's hewn in stone, it's word processing. So, the funny thing is I had clients who did, a couple that did their wills, and they came back in the 6 months, they changed it 7 different times. The nephew was in, and the nephew was out, and each time they joked and they laughed that they never left the law office paying less than $20 for their bill. So yeah, this is something that can be changed very easily. To get more specific into the documents, like the power of attorney, the key fact there is typically with a married couple, they'll do each other, and then the question is who's going to be the successor in case something would happen to the two of them.
If they were, for example, traveling together and
Correct.
were in a car accident together and we're both in the hospital, they can't make decisions for each other.
Absolutely. And for young married couples, that's imperative that they make that decision to pick that successor agent in case something would happen where one of them would either die or both of them would be incapacitated at the same time.
Right. Let's jump into some of those more specific ones. The power of attorney, which you've mentioned a few times, what specifically does the power of attorney do?
It gives authority to an agent to make decisions for you. Now, power of attorney comes in two different flavors. There's what they call durable power of attorney or general power of attorney, and then there's a springing power of attorney. A durable power of attorney, when it's signed, and then the agent has to accept that, so they sign an agent's acknowledgement. Upon their signing that agent's acknowledgement, they accept the power immediately upon signature.
Okay.
Okay, so it becomes a live document at time of signing. On the springing power of attorney, there's a condition precedent, and that is that two physicians would declare in writing that the person was either incompetent or incapacitated, and the power would then spring into the agent.
Okay.
So for a married couple, it's usually a durable power of attorney because they may need it even when they're both conscious and competent, in that banks and other institutions, if the account is singularly titled, the wife or the husband doesn't have legal access to it.
Right.
The power of attorney would allow them to make decisions if one travels or just isn't around, and the other one would need to make decisions or take action on an account.
Okay. I was just going to ask what the difference, or in what situation people are going to use durable power of attorney.
Right, so then a single individual, and we have plenty of them, where either their spouse had died or they've never married, they would choose a springing power of attorney because they don't need someone to take care of things for them now.
Right.
They would only need it in case something would happen to them in the future, and then the power would spring into that agent.
Right. That makes sense. This might sound like a ridiculously silly question. Power of attorney doesn't have anything to do with being an attorney.
No, it doesn't.
Okay.
No, it doesn't. I'm not sure the derivative of the name of it, but no, it has to do with, it really has to do with an agent.
Okay. I think a lot of times, and I hear this occasionally, people think that that you would be the power of attorney as the attorney, that it's essentially giving your attorney the power to make decisions for you, but that's not what it is, apparently.
No, I've never heard that before, but no, that's not what it is. And in very rare situations does that happen.
Okay. Let me ask you, from your experience, usually who do you recommend people make as their power of attorney?
That's a good question. I mean, with a married couple, it's easy because it's usually each other, and then usually they'll pick either a child or one or both of their siblings, or their parents if their parents are still around and are still
as a contingent
cognizant. That would be the contingent.
Okay.
The subsequent agent.
Subsequent agent.
Yeah. It gets more difficult when you get relationships where there isn't those types of where it's each other or and we always say it's got to be somebody who's financially somewhat on the ball, because they're going to have to pay all your bills for you. So they have to be able to be organized and financially have some acumen so they'll be able to take care of things. So you wouldn't want to pick somebody who's bad with their own finances. You want to make sure it's somebody who's good with their own finances because they have to manage your finances.
So to that end, parents, if their children are still young, if their children are 15 or 16, they may know their parents' wishes, but they may not make the best power of attorney if they don't have the financial acumen to make those decisions. Or
well, they'd have to be 18 anyway, but even when you get into your 20s, and I've seen children that are in their 30s and 40s that I wouldn't want chosen for the power of attorney. But yeah, no, they're usually the best decision, but they have to have the acumen to be able to do it. But it isn't that difficult. It's just paying bills. It's just being organized. Are they organized enough to be able to take care of that?
What happens if someone doesn't have a power of attorney, and then, or I believe you said the spring power of attorney. So let's say someone doesn't have one, they get in an accident, and they're unconscious. What happened? Who makes the decisions?
So if somebody was, or a best case scenario, I mean, not best case scenario, but like a scenario where this happens is someone would be in an induced coma.
Okay.
Maybe they're a single individual, and now they have, they have an apartment, they have a car payment, they have all these things going on financially, and they don't have anybody named as a power of attorney. What ends up happening is someone has to go to court and be named guardian of that person.
Okay.
It's an expensive process. It's a long, drawn-out process. It takes some time because you have to go to court. You have to go to a special court in that it's orphans court.
Okay.
So it's different than civil court. And then they would have to be named as guardian. They'll have to sign and pay for a bond.
Oh, wow.
Yeah, they have to be insured in case something would happen. So, I mean, that's where I always say to people, it's a lot less expensive to do it now and name the people who you want than it is to later on wait and have to go to court. That's why it's like insurance. You pay a little bit now and it covers you
later
in case something would happen.
Right. What would the cost difference roughly be for someone filing a POA with a law office like yours now versus having to go to court on the
When you talk about the difference
guardian?
between $100, hundreds of dollars, and thousands of dollars.
Oh, wow.
Yeah.
Wow.
Plus, it's difficult. It's never fun, even for lawyers, to stand before judges and have to make an argument as to why what they're requesting should be granted.
Right. And can judges deny that? The guardian
They can.
case?
What actually happens is typically what will happen is you'll have two people vying for the same agency, so to speak, and then it becomes an issue of, well, who's more competent and who would better serve the person who's incapacitated.
So the POA or the power of attorney or the POA also puts the decision in your hands as an individual then. So you can decide who would make decisions for you, as opposed to if you don't have one and it goes to a court, the court ultimately decides.
Correct. Yeah, that's right.
Who makes decisions for you.
That's right.
Last question on the power of attorney side of it, the final will, which we'll get to, if you have a power of attorney, someone's making decisions for you, does that end if you pass?
That's a great question, and a lot of people will say to us, "Well, I'm power of attorney, so I'll take care of the estate." And what they fail to realize is with the power of attorney and with the advanced healthcare directive, both die with the person.
Okay.
So, that's when the will would kick in, and there's different things that we can discuss later as to how that whole process occurs.
Okay. So if the person passes, the power of attorney goes with
Power of
him or
attorney
her.
dies with the individual.
The person. Okay. Richard, thank you. Don't go away. We'll be right back. Welcome back to Face the Issues. Richard, thank you again for taking the time. When we left off, we were talking about the power of attorney. One of the other things that you have brought up, in addition to that, you said the power of attorney dies with the individual. And the other thing that goes as well is the advanced healthcare directive. Let's jump into that a little bit. What is an advanced healthcare directive?
Well, an advanced healthcare directive is a document that accomplishes several tasks. The broader way of looking at it is what the power of attorney does financially, the advanced healthcare directive does medically.
Okay.
Now, there's some other things because of HIPAA and other federal regulations. The agent under the advanced healthcare directive has to have, and there's a section in there, has to have access to the records first. Okay. And it releases the medical professionals from their duty of privacy and allows them to talk to that agent and release that information. Okay, so it releases the information and then it vests power in that agent to be able to make medical decisions. Now, it acts like we talked about the durable power of attorney and the springing power of attorney. The springing power of attorney requires a condition precedent or something to happen for it to vest in the agent.
And the doctors sign off and all that?
No, this is on a regular power of attorney.
Right.
For the advanced healthcare directive, doctors sign off. For the advanced healthcare directive, there is a condition precedent, and that is that the person can't make their own medical decisions. Okay. So they have to be unconscious.
Okay.
Or incompetent.
Okay.
So that unlike the durable power of attorney that vests right when you sign it, the agency under an advanced healthcare directive has to have that condition precedent that the person be unconscious for it to vest.
Okay.
Now, the critical thing about naming the agent for an advanced healthcare directive is unlike the power of attorney, is this requires a person to be present. So, for instance, I always say to clients when they ask, who should I pick? It should be the person who's going to show up at the emergency room if you got into a car accident or something would happen to you. So, for instance, if an individual's daughter lives in California, but is an accountant, well, there'd be a great choice for a power of attorney, but they're probably not the one who's going to be showing up at the emergency room to answer any questions that the medical professionals would have. So you'd want to do that. And unlike the agency in a power of attorney, where you'd only really need one person, you may want to name multiple people to be co-agents because you never know who's going to be there when a doctor has
I was
to make
just
a
going to
decision.
ask you that. If someone travels, or there are people who they have a summer home or they winter somewhere, then does it make sense for them to have one in each of the areas they're spending significant time? Because if they're wintering in Florida but they're living here, and something happens when they're in Florida, it would make no sense if their kid who lives in Pennsylvania is the agent.
Correct. That's a great point, and absolutely, that's why we name co-agents, because you never know who's going to be there. But you want it to be someone who's sensitive to your desires, because a lot of people have very strong desires as to how they want, particularly end-of-life decisions made. And someone might say, well, a 20-year-old's not going to be dealing with an end-of-life decision. Well, if they get in a car accident, they may.
Right.
So the Advanced Healthcare Directive, to get back to it, is broken into 3 parts. The first part is a notice. It has to do with HIPAA requirements and things like that. The second one names the agent, just like the power of attorney for financial reasons. And then the third part is, a lot of people talk about a living will. And that's an old term that used to deal with an old document. They were drafted, or they were created because of, and I can't remember the woman's name, there was a woman in New Jersey that was kept alive on life support. It was when medical technology advanced beyond the law. So she was kept alive, but in a vegetated state, had no chance of recovery. And the family was struggling with what they do. So they decided that they said goodbye and they wanted to let their loved one go, but the medical community said, we're not going to do that. We're under our Hippocratic oath that says we have to keep people alive.
Right.
So what happened is the legal community reacted to that, and they drafted what they called living wills. And that basically said, in a vegetated state, we're allowing our agent to pull certain medical treatment and allow us to die naturally. So in our advanced healthcare directives, we give the agent power, but then we also deal with this condition, which is we call an end-of-life condition.
Okay.
Now that's defined as 2 physicians declaring in writing that there is no hope for significant recovery. That can occur in many settings. One in particular, we talked about the car accident.
Right.
I go through the windshield, half of my brain is taken off. There's no chance I'm going to have significant recovery, so I now am in that section of the document that says, I'm in my end of life situation. Another one may be, my father died of a stroke. It could be a person who has a stroke, and there's no chance of significant recovery for that individual. That would get them into the end of life. Another one might be cancer. They have cancer and now they're unconscious. They would be in an end of life.
Do they have to be in an unconscious state?
Yes, because remember, for this document to spring into effect, you would have to have the first condition precedent, which is unconsciousness or incompetence.
Okay.
And then for the third part of the document to go in, or ours, to go into effect, it would require them to be in an end-of-life situation. Okay? Now, in that situation, the document and the law requires that an individual make an affirmative choice. So they have to put an X or a check mark by different types of care that they would want, like resuscitation, blood products, trying to think of any, diabetes products, medicines. So for all those things they would check, I do not want, if they would like to die naturally in that situation. Obviously, pain and things like that are covered. The patient is always kept comfortable.
So palliative care never goes away.
That never goes away. This has to do with continuing care that would be such that would keep the person alive.
Prolong their life.
Alive, to prolong life.
Okay.
Okay, does that make, I know I covered a lot.
That's a lot.
A lot to unpack, but the document has, and this is usually when we're doing estate planning, if you can believe it, in the signing section of estate planning, this document usually takes 2 to 3 times more than even the will, because we have to go over this so that people understand that this is decisions that they're making end of life. Again, it's not Moses on the mountain. They can always get it changed, but they have to understand that. In addition, there's a little bit of a friction through the medical community and the legal community in the sense that the vesting that power in the agent is something where the agent will say to the doctors that are treating, to the treating physicians, hey, it's time. The physicians, because of their Hippocratic oath, it's difficult for them at times. So and this is something that we tell people, when they're deciding how much authority, and in the document they can give the agent different levels of authority. When deciding how much authority to give to that agent, I always suggest and recommend the broadest power, because you're going to have to they may have to overcome a physician who is resisting that.
Sure.
And we've had cases where we've had to be very clear to the physicians, And it's not a bad thing.
Right.
It's because their desire is to cure.
Right.
Their desire is to prolong life. It's not a negative on their part, but at some point, sometimes the agent has to say, you know what, this is my mom, this is my dad, this is my friend, and you know what, we've discussed this, and she wouldn't want this anymore. And the ability to be able to say that is based upon how much authority the person gave to their agent. So however they're sitting down with their attorney, they should go for I recommend going for the broadest power so they don't have to face that situation where they're wrestling with the doctor and saying, no, you have to, you have to do this.
What happens, same question as with power of attorney, what happens if you don't have an agent in place? Someone doesn't go through the estate planning process and they end up in this situation, who calls the shots?
That's a great question. Again, they would have to go to court and get a guardian named to make those decisions. So there's time. And in the meantime, that person would be kept alive on life support. Which may not be something that they chose. And telling someone, well, I don't want to be on life support, and is a lot different than putting it in a document saying, I named this person my agent to make decisions for me.
So the doctors will do what they do then until someone becomes guardian.
Correct.
Okay. And also, like the power of attorney, you said this goes with the person.
This dies with the person, correct. It's an agency that would die with the individual.
Okay. If let's say someone has, and we'll get into wills, let's say someone has a will, do they not include this in the will?
No, because remember, the will doesn't come into effect until the person dies.
Until they're deceased.
Yeah.
Okay,
Yeah.
so all of this is before someone passes.
This is before death. And you can see, in the case, there was a young woman in Florida where there was a case.
Correct.
These are important documents for young people to have, because a young person's going to be on life support a heck of a lot longer than you and I, who are old guys.
Thank you, Richard.
So it's an important document. And I've had clients who have a lot of foresight, and they'll have their children come in and do these documents with them and explain to them why.
Even as a child?
Teenager, as soon as they're age of majority, 18 on. This one they had 2 kids in college and then a young 20-year-old.
Wow. Okay. Well, thank you, Richard. Don't go away. We'll be right back. Welcome back to Face the Issues. Richard, a lot of good stuff today. Thank you again for taking the time. We're going to have you back, and we're going to jump into some of the other things that you're talking about, the estate planning, including wills. But let's give the audience a bit of a preview with the idea of the will, which I think is the most well-known piece of estate planning. But let's just give them a bit of a preview. What is it, and how does it fit in with what we talked about today?
Well, where it fits in is the will, all the other documents are in effect until death. The will then takes over at death. And with conversation of a will, always should be a conversation of estate administration, because a will determines where things go through the estate. But I think it's important, and you want to, as a look back, you want to be comfortable with your counselor, the lawyer that you choose, that they're answering all your questions. One of the things before we close I wanted to go over is these documents are the individuals. They're not mine. My job is to put what their desires are on paper.
Right.
So if you don't understand something about your power of attorney or advanced healthcare directive or living will, some attorneys may call it, take the time and ask them the question. If they bill by the hour, I'm just going to tell you, it's a good investment, even people who bill that way, because you have to be comfortable that you understand it, so that your choices are your own and they're educated.
At the end of the day, you're the one that it impacts.
Correct. And the lawyer, the job of the attorney is to put your desires on paper. That's true for the power of attorney. There's not much to choose there, but it's true for the advanced healthcare directive. And then when we get into the wills, it's really important for the wills, because there's a lot more choices that you can make, or ways you can go with your will, depending upon what kind of assets you have, whether it's a house, a car, a boat, or 401ks or IRAs.
All of that is included in the term estate.
Yeah, an estate, and this is a great question. An estate is your estate when you're alive, is the things you possess when you're alive, and then that's called an inter vivos estate, with time of living. And then there's your testamentary estate, is when you die. That's your estate. That would be a snapshot of all your assets when you die.
Okay, is that why they call it a final will and testament?
Well, it's final will and testament because if it's not the final one,
well,
then it isn't in effect.
The question pertains more to testament than final.
So it's usually the reason why it's called final, meaning it's the last one. So you can have several final ones, but it's the final one that, not to be Monty Python-esque about it, but it's your final one that ultimately has a power and authority.
Right. One more time, I know we started off with this. When you recommend everyone, no matter how old or young, get this? What's the minimum age someone has to be?
18.
18.
Yeah, you have to be the age of majority to make your own decisions.
So before that, their parents would assume that right.
Correct.
Okay, so you recommend anyone as young as 18 to go ahead and get this process started?
If they have an estate, particularly, yes.
Okay.
If they have some property.
Great. Well, Richard, thank you for taking the time. We'll be back and jump into the rest of estate planning next time we're on. Thank you for making the time today.
Thank you for having me.
Absolutely, my pleasure. That is all the time we have tonight, but don't miss next week. We'll be back with Richard to address the second half of estate planning and go more into detail with wills and what all of that entails. Until then, you can continue this conversation online. Just use the hashtag #FaceTheIssues. My name is Sam Chen. On behalf of all of us here at Face the Issues, thank you and good night.